If you have been involved in a car accident and you choose to file a personal injury lawsuit, you will reach the interrogatory stage. This stage involves one party sending questions to another in addition to asking for information about any issues they have with the case. The answers given will need to be in writing and under oath. The answers will also have to be served within approximately 30 days. Your state will have a case law and rule of procedure that specifies how many questions you can ask, when you can and must object to some questions, as well as how much time you have to respond to the questions. You will also learn how the answers you have been given can be used in your case. Sending the defendant interrogatories. You have the option of sending interrogatories to the person you are suing. Occasionally, these are sent to the defendant at the same time as the initial complaint. As part of the interrogatories, you will need to ask the defendant to identify who they are, state their version of the accident in detail, identify anyone who witnessed the accident, reveal the documents that will be used in the trial, identify anyone who will be used as an expert witness, describe what condition they were in before the accident took place. In other words, if they had been drinking or if they have any physical disabilities. Describe the condition that their car was in before the accident took place. In other words, if it had anything wrong with it that may have contributed to the car accident. State any contentions that they may have. In other words, if they think they had acted negligently. How much car insurance they have. Please note this question is not allowed to be asked in every state. Receiving the defendant's interrogatories. The lawyer who is working for the defense is likely to send interrogatories along with the answers to your interrogatories, also known as your complaint. The interrogatories you are sent are typically the questions the defense lawyer in question tends to use in a car accident case. As part of the interrogatories, it's likely that you will be asked to identify who you are, state your version of the accident in detail, identify anyone who witnessed the accident, reveal the documents that will be used in the trial, identify anyone who will be used as an expert witness, describe and list your injuries. List all of the healthcare professionals that you've seen for the treatment of any injuries you sustained in the accident. Provide details about your health before the accident took place. List all of the financial losses that you are making a claim for, such as loss of income and medical bills. Your earning and employment histories. Documents that you are likely to use in the trial. If you are represented by a lawyer, they will help you to answer the questions that the defendant sends you. If you do not have a lawyer and are happy to represent yourself, you should make sure your answers are carefully prepared, as an incorrect answer could damage your claim. You should also be aware that in some states you are required to supplement your answers if any of the facts change. For example, if you need more medical treatment for your injuries, you will need to supplement all of your answers and prove that you've needed to pay for more treatment. If you fail to do this, you will not have the chance to show any more evidence at your trial. Your objections to the interrogatories. The court will determine when you should object to the interrogatories. In some cases, you may be able to use a written objection. However, in some cases, you may have to file a motion that asks the court to enter a protective order. This order means you will not have to answer the question. Please note that you may not be able to ask some questions if they have not been deemed appropriate. When you file a lawsuit, you ultimately give up some privacy, which means the defendant is perfectly entitled to ask you questions that can be relevant or those which can lead to the discovery of admissible and relevant evidence. This means that you may have to answer a few questions that may not seem related to your car accident case. The good news is that you do not give up all of your privacy just because you have filed a lawsuit. Any questions that are deemed irrelevant do not have to be answered. If there is a question that you do not wish to answer for legal reasons, you will need to object and seek a protective order. Alternatively, you can also do what you deem necessary to avoid giving an answer. You should not be surprised if the defense objects to any or all of your questions. This could occur because defense lawyers may do what they can to make you frustrated. In a case such as this, you should argue your case, and you may find that the court supports you if your objection is valid. The advantages of interrogatories. One of the biggest advantages of interrogatories is that they do not cost very much. You will have to use paper, some stamps, and a bit of time to prepare them, but the costs are very low. The disadvantages of interrogatories. The disadvantage of interrogatories is that they very rarely offer you any detailed information. This is because the defense counsel will draft the responses and they will only ever provide very basic information. If you would like more information about the defense, you will need to use discovery procedures such as depositions. Please read our article The Discovery Phase of a Car Accident Case for more information. Interrogatories can be quite useful when it comes to obtaining background information and learning who the witnesses are and more, which is why you should use them.